Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back on a huge case that just came out of the state of Washington. It's State of Washington versus Gators Customs Guns. We've already been through the majority opinion and talked about the very dangerous argument that was accepted by the Washington State Supreme Court, an argument that we're also seeing pop up in Illinois, and how it literally could be used two separate ways as an end around from a court's otherwise constitutional obligations. Today, we're going to focus on the dissenting opinion in the Gators case out here in Washington State because it was authored by a judge who, candidly, I don't think politically lines up normally with Second Amendment advocacy. I don't think that perhaps this judge sees the world the same way we do, but it's a really intelligent judge who happens to understand that words have meaning and case law actually has precedential value. And so today I want to go through the arguments because it really shows how somebody with some intellectual integrity can take apart one of these arguments in relatively short order. So today, let's spend a few minutes and let's talk about how to dismantle a gun control argument. Okay, America, listen, this case comes out of Washington, but it applies to a lot more than just the hometown crowd because there are arguments afoot nationwide right now where the Constitution only protects arms which are in common use for self-defense. And if that were the test, that allows government to do one of two things. Either A, they get to determine what's appropriate for self-defense, and if they decide it's not, they get to ban it, or they could just say that you proved that it might be in common use, but you never proved to us it was in common use for self-defense, so we get to ban it that way also. That's exactly what the Washington State Supreme Court decided in our magazine ban case by a vote of 7-2. Now, we had predicted that Justice Gordon MacLeod on the day of oral arguments would be the lone dissenting vote. It turned out there was an additional dissenting vote, but it was Justice Cheryl Gordon MacLeod, who is a longtime defense attorney out of King County, Washington, an incredibly accomplished appellate attorney, an incredibly accomplished attorney in general, recipient of numerous awards, and for good reason, elected to the Washington State Supreme Court and brings with her a tremendous amount of intellect and intellectual integrity. And I would fathom to guess that Justice Gordon MacLeod does not necessarily agree with most of us politically. However, she absolutely positively understands the meaning of words and the precedential value of clear case law because she opens her dissenting opinion with, "The Second Amendment protects the individual right to keep and bear arms. More specifically, it protects the right of law-abiding people to keep and bear arms in common use, not just arms that the government approves of. And it protects that conduct when it is done for lawful purposes, including but not limited to self-defense, not just when it involves returning fire, as the state seems to contend." But she also points out that, even if your ludicrous position was accepted, you're still going about this the wrong way. "We don't measure whether an arm is in common use for self-defense or other lawful purposes by counting the number of rounds an average desperate victim is able to discharge when forced to return fire. And the problem with this in common use for self-defense, which is going to be a complete and utter abomination to Second Amendment rights, and Justice Gordon MacLeod gets it when she writes, "Finally, the state argues that we should view our nation's early limits on the right to keep and bear arms at an extremely high level of generality, so high that we characterize those old laws as barring weapons once society weighs their utility against their danger and decides that they are too dangerous. But that is precisely the sort of policy-laden interest balancing that the United States Supreme Court has explicitly barred under the Second Amendment. And it is this sort of interest balancing that repressive governments have historically used to suppress opposition." Now, I only want to focus on one portion of her very, very fantastic dissenting opinion, which of course is all linked up down below, which is this in common use for self-defense. Because Justice Gordon MacLeod uses simple English, common sense, and logic to rip this argument to shreds. Starts this way. "The state argues that even if LCMs are commonly possessed by law-abiding Americans, they are not widely used for self-defense. This argument fails for several reasons. First, it's a complete and absolute misstatement of the rule of law. The first problem with the state's argument is that, as mentioned, the Second Amendment does not exclusively protect the right to keep and bear arms in self-defense. It covers the right to keep and bear arms in common use for other lawful purposes, including hunting, target practice, and the like. And it kind of defies the rules of, simple English. The second problem with the state's argument is that its definition of the word use defies common sense. The state acknowledges that guns can be used in self-defense without having any shots fired. The state undermines this acknowledgement by going on to assert that LCMs are not commonly used for self-defense because it alleges individuals are rarely forced to fire more than 10 rounds in self-defense. And so if we're going to determine the usefulness based upon what is the average number of rounds discharged that the state believes through their experts, again, Justice Gordon MacLeod points out this is pretty ridiculous in the following way. Under the state's argument, unless a user fires 10 or more rounds, she has not used a firearm equipped with an LCM for self-defense. But as discussed above, keeping and bearing a firearm for self-defense covers a lot more than returning fire, even if the state's 2.2 shot statistics were trustworthy, which is debatable. It covers storing, training, teaching, practicing, and keeping a home prepared. The state's argument that the average number of shots fired in self-defense determines whether LCMs are in common use for self-defense contradicts Heller, which held that the Second Amendment protects arms that are typically possessed for lawful purposes. And then Justice Gordon MacLeod, who clearly did her homework, points out that, hey, the United States Supreme Court, in a per curiam opinion, found that Massachusetts' ban on stun guns was unconstitutional, and nobody ever had to establish how frequently stun guns had been used. And again, the dangers of allowing this in common use for self-defense is it allows the state to become firearms and tactical and self-defense experts. Or as Justice Gordon MacLeod puts it, the state continues that firearms equipped with LCMs have virtually no utility for self-defense because they are capable of firing more than 10 rounds. It even asserts that such a weapon is disadvantageous for self-defense. It is hard to understand why having additional ammunition at the ready would make it harder for a frightened victim to act in self-defense. And yet, despite the absolute ludicrous nature of all of the arguments, Justice Gordon MacLeod also points out, but you know what? Even if you're right about everything, it still doesn't matter. But even if the state's assertions were true, it is irrelevant. It amounts to an argument that the state alone gets to select the arms that individuals can use for self-defense and other lawful purposes. But the Second Amendment doesn't protect the right of the state to choose the best arm for self-defense. It protects the right of the individual to make that choice. So despite what the state prefers under Heller's in common use test, the popularity of an arm among the law-abiding public actually determines whether that arm enjoys Second Amendment protection. So listen, not only is this argument incredibly intellectually effective at destroying those on the civilian disarmament side and their bastardization of the common use test, but more importantly, it's rather refreshing. It's rather refreshing to know that there are judges out there who may not see the world the same way as us, but completely understand what their sworn duty to do as a judge is. And they understand their obligation to uphold the law and to uphold the Constitution and preserve the rights of American citizens. And most importantly, they understand that words have meanings, so do statutes, and so does case law. And for that reason, Justice Gordon MacLeod here in Washington State should be commended for this dissenting opinion. But more importantly, for those of you around the country that are going to have to fight this same fight that we had to fight out here, this is the blueprint for how to get it done. The case, once again, is State of Washington versus Gators Customs Gun. We're going to link it all up down below so you guys can geek out on it for yourself. Maybe you got questions about this or something else related to what's left of our Second Amendment rights. If you guys do, you should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.